Criminal Justice Mental Health Consensus Project. For the past few years, the Justice Center has partnered with the Office for Victims of Crime to oversee a project focused on victims of crimes committed by people with mental illnesses. Last year, as a part of this effort, we released a guide to the role of crime victims in mental health courts. This guide was developed with expert input from staff at BJA, as well as the BJA Mental Health Court learning sites, 5 courts designated to provide a peer support network to those interested in planning or improving upon their mental health court operations. Throughout, we will make reference to this guide, and please note that it is available for free on our Consensus Project website and through the link you will see at the end of my presentation. With that, I want to provide some background on our 2 guest speakers, both of whom were integral in the development of this guide. Carol Doris is the Senior Staff Attorney in the Public Policy Department at the National Center for Victims of Crime. She is also the Director of the Victim Law Project, an online database of federal, state, and tribal victims' rights laws. Carol will provide context on how victims' rights are traditionally upheld in the criminal court context to provide a comparison to mental health court operations. Tim Murray has served as the Executive Director of the Pretrial Justice Institute since 2006. His pretrial services experience includes positions with the pretrial services systems in Washington, D.C. and Miami-Dade County, as well as within the U.S. Department of Justice. He has provided technical assistance to numerous programs and organizations, including grantees of BJA's Justice and Mental Health Collaboration Program during his tenure at PJI. Tim will discuss his observations about how many mental health courts are currently working with victims, key challenges to involving victims, and reasons for involving victims in mental health court processes. I will then discuss key recommendations from our guide and how mental health courts can adapt many of the practices upheld in traditional criminal courts for the mental health court setting. With that, I'll turn it over to Carol Doris.
Crime, which consisted of a series of legal bulletins on kind of current hot topics, one of which was the status of victims' rights laws for victims of individuals with mental illness. Based on that research, I was involved in work with the Justice Center to develop a guide on improving responses to victims of individuals with mental illnesses, and also provided some input on their publication that is the topic of today's web training. I did want to mention that one of the things we realized over the course of this work is that the terms used in the criminal justice system and the mental health system may be very different. So if I use a term that's unacceptable in one or the other, I apologize for that in advance. I just wanted to give a brief history of victims' rights, and I'm going to be moving pretty quickly because there's a lot of material here to cover. I wanted to talk a little bit about the status of victims' rights in 1982. 30 years ago, victims had few legal rights to be informed, present, and heard within the criminal justice system. Victims did not have to be notified of court proceedings or of the arrest or release of the defendant. They had no right to attend the trial or other proceedings, and they had no right to make a statement to the court at sentencing or at other hearings. Victim assistance programs were virtually non-existent. And to give you an idea about the number of states at that time, only 4 had comprehensive laws for crime victims. 8 required victim impact statements at sentencing, and only 8 mandated restitution. I used the year 1982 as a pivotal year for the victims' rights movement because that's the year that President Reagan created the President's Task Force on Victims of Crime to address the needs of those who are victimized by crime every year. The resulting report contained 68 recommendations, and that laid the foundation for the victims' rights laws that we have today. Since then, there have been tremendous strides in the creation of legal rights and assistance programs for victims of crime. Today, every state has an extensive body of basic rights and protections for victims within its statutory code. In most states, crime victims have basic rights to be informed, to be present at certain hearings and at trial, and to speak at sentencing and specified release hearings. They can receive restitution for their losses and protection from intimidation by their perpetrators. Some classes of victims, such as victims of juvenile offenders and individuals with mental illness, were generally excluded from this initial wave of victims' rights laws. In recent years, there have been major efforts to extend rights to victims of offenses committed by juveniles so that most states also provide rights to those victims. Victims of individuals who are mentally ill, however, still seem to have fewer rights than the rest of the crime victim population, even though the crimes committed are just as traumatic and harmful to the victims. When individuals with mental illness who commit crimes are convicted in criminal courts and sent to correctional facilities to serve their sentences, their victims have the same rights afforded to all crime victims. However, in most states, when an individual found to be mentally ill to the degree that he or she is found incompetent to stand trial, not guilty by reason of insanity, or guilty but mentally ill, the jurisdiction usually transfers to the mental health system. And there the concept that victims may be involved who have concerns and needs may not be as well known as in the criminal justice system. Some states do mandate rights for victims of the mentally ill, and they've incorporated provisions for victim notification, participation, and protection into their laws. A few of those have extended their general victims' bills of rights to include these victims, adjusting applicable definitions to ensure coverage. Other states have passed separate laws which apply to victims of offenders who are found not guilty by reason of mental defect or disease or guilty but mentally ill. And a few states use both of these methods. I wanted to talk a little bit about some typical rights that were specifically addressed in the Justice Center's guide that we're looking at today. The first of those is the right to be treated with sensitivity, fairness, and respect. Ensuring the proper treatment of crime victims is perhaps the most fundamental of all rights. If victims of crime feel disrespected, or if they have not been treated with sensitivity, they're unlikely to come forward to report offenses and participate in the prosecution of their cases. And this undermines the entire criminal justice system. In addition, the failure to treat victims with dignity, respect, and sensitivity compounds the trauma victims have sustained from the crime itself. The next right is the right to be informed. The criminal justice system is often required to provide general information of interest to victims. Most states also give victims or their families the right to be notified of important scheduled criminal proceedings and the outcomes of those proceedings. They also notify victims when hearings have been canceled and rescheduled. Some of the general information that criminal justice officials are often required to provide include notice of the availability of crime victim compensation, referrals to victim services such as rape crisis centers, battered women's shelters, and general victim service agencies, and information about the steps involved in a criminal prosecution. In addition, they may also have the right to be informed of their legal rights, including the rights to attend a proceeding or submit a victim impact statement, sue the individual for money damages in a civil action, or have a court order that will protect them from the individual or the individual's family. There are dozens of events or proceedings in the ordinary criminal justice process for which notice may be required by statute, and I'm just going to mention a few of those more commonly known. That would be the arrest, arraignment, pretrial release, plea bargains, trial dates and times, sentencing hearings, post-trial relief proceedings, and the escape and subsequent recapture. Some of the notice requirements mentioned here have been more widely adopted by states than others. For example, nearly every state notifies victims of the trial date and time and the sentencing hearing. Fewer states notify victims of the offender's release on bail. Following conviction, most states notify victims of a parole hearing or parole release, but only a few notify them of a pardon or commutation of sentence. Right to attend is the next right that we'll look at. Most jurisdictions give crime victims and their families the right to be present during criminal justice proceedings. This right's important to victims who often want to see the criminal justice process at work. They may want to hear counsel's arguments and view the reactions of the judge, the jury, and the defendant. The victim's right to attend proceedings includes the right to attend the trial, sentencing, and parole hearings. That may include other proceedings as well. Some states provide that victims have the right to attend those proceedings at which a defendant has the right to be present. A number of states also, along with this right, give victims the right to have an advocate or support person present during the proceedings, which can be really comforting and helpful to a victim. Moving on to the right to be heard, one of the most significant rights of crime victims is the right to be heard during criminal justice proceedings that affect their interests. When a crime victim is allowed to speak at a sentencing hearing or to submit a victim impact statement, there's an acknowledgement by the criminal justice system of the personal nature of the crime and of the harm suffered. Now, the right to be heard can be exercised in a number of ways. One way is to confer with the prosecutor, which means that the prosecutor is required to obtain the views of the victim before a disposition is final. Most jurisdictions also give victims the right to be heard by the court or another authority such as the parole board before major decisions are made. every state allows some form of victim impact information at sentencing. A majority of states require victim impact information to be included in the pre-sentence report and allow victim impact statements to be presented at the sentencing hearing. Generally, the law specifies that victim impact statements may be oral or written, but in several states now, that statement may also be submitted by videotape, audio tape, and other electronic means. Victim impact statements may be given by the victim, homicide survivors, or the parent or guardian or representative of a minor victim, or a family member or a representative of an incapacitated victim. The victim impact information usually describes the harm that has been caused, including the financial, physical, psychological, or emotional impact, harm to familial relationships, and any medical treatment or psychological services that were required, as well as the need for any restitution. In addition to allowing victim impact statements at sentencing, the majority of states also permit victim input at the parole hearing of the offender. Many jurisdictions give victims the right to protection during the criminal justice process. This right may take the form of a generally stated right to protection or may include specific protective measures. For example, most jurisdictions have defined criminal offenses of intimidation of victims or witnesses. And other protective measures that states have used are police escorts to and from court, secure waiting areas in the courthouse that are separate from those of the accused and the accused family, witnesses, and friends, witness protection programs, residence relocation, and putting in specific conditions on bail release, such as no contact orders. And finally, I'll move on to the right to restitution, which generally refers to restoration of the harm caused as a result of the crime, most commonly in the form of payments for damages. It can also refer to the return or repair of property stolen or damaged in the course of the crime. Courts have the authority to order restitution by individuals who are convicted as part of their sentences. In approximately one-third of the states, courts are required to order restitution to victims in cases involving certain types of crime, typically violent felony offenses. In many other states, if the court fails to order restitution or orders restitution for only part of the losses, the court must state its reasons for doing so on the record. And restitution can cover out-of-pocket losses directly relating to the crime, and I'm just going to mention a few of those. Medical expenses, counseling costs, lost wages, lost or damaged properties, and a number of other things. But in no case is restitution ordered for for pain and suffering. I'm going to move on to some of the typical costs of, or the typical rights that weren't specifically dealt with in the guide, but were mentioned, just briefly mentioned in there. And those are the right to speedy trial, the right to return of property, the right to privacy, the right to apply for compensation, which I may touch on again if I have a minute to do that, and the enforcement of rights. I just wanted to briefly mention that 32 states today have constitutional provisions addressing crime victims' rights. And Montana also amended its constitution to broaden the principles underlying the criminal justice system to include restitution to crime victims. We don't include that in the 32. Other people do include that, so we would say 32 or 33, depending on your take on it. And those would be the darker gold states. I just wanted to briefly talk about who is a victim. Depending on exactly who the law considers a victim entitled to a particular right is defined by the federal, state, or tribal code. In some states, the rights are only afforded to victims of felonies, while in others, victims of any violent crime, whether it's a felony or misdemeanor. And many extend victims' rights to surviving family members as well. I listed some various things here, and depending on the state you're in, given state, you may or may not be considered a victim under one of these categories. I'm going to try to just briefly talk about some specific rights that have been enacted by states on some of these different issues for victims of individuals with mental illness. First, I want to talk a little bit about the right to be informed. Notification can take on a new meaning for victims of individuals with mental illness. whether the person is a stranger who randomly commits a crime or a family member who assaults his or her caregiver. The uncertainty of how that illness may influence his or her actions can create an additional element of concern for victims. States have enacted laws to notify such victims of competency petitions and proceedings, review hearings, changes in the offender's status, offender transfers to mental health facilities during the course of incarceration, discharge or release proceedings, conditional and unconditional releases from confinement, and of the offender's escape from custody. In many states, victims must request this notification. And I'm just going to give a few brief facts, and then hopefully we can get back to this in the question and answer if people are interested in specific examples. Approximately half the states have adopted provisions to notify victims when the individual who committed the crime is released from a mental health treatment facility. As far as the escape of a victim, while victims are provided notice of the escape of a convicted offender from a correctional setting in almost all of the states, only about half require victim notification when an individual escapes from a mental health facility, institution, or state hospital. Moving on to the right to attend. The right to attend is a little trickier in mental health court proceedings due to the privacy consideration. And I just want to mention Washington's law because it addresses both of these issues, and I'm going to read some of that content of that statute. To prevent wrongful disclosure of information related to mental health services, a court may take only those steps necessary during a sentencing hearing or on any hearing in which the department presents information related to mental health services to the court. The court may seal the portion of the record relating to information relating to mental health services, exclude the public from the hearing during presentation or discussion of information relating to mental health services, or grant other relief. So that, I think, is helpful. And in a number of states, victims are permitted to attend proceedings for the limited purposes of presenting a victim impact statement. And quickly moving on to the right to be heard, a few states have incorporated victim impact information provisions into their commitment processes. In Washington, victims of individuals with mental illness may also participate at sentencing. And a few states, like Connecticut, have enacted laws giving victims of the mentally ill a right to be heard in the review or release process. Allowing victims to submit impact testimony, and such testimony serves to remind psychiatric review boards and courts of how the individual's conduct continues to impact victims' lives. They also may be able to participate in change of status hearings. Quickly, the right to protection. Victims of individuals with mental illness have many of the same safety concerns as other victims, and we've already talked about how notification of release is one means of protecting victims' safety. States also use no-contact orders and court-imposed conditions of release to protect victims of the mentally ill. Because many states are moving on to the right to restitution, because many states consider restitution to be a form of punishment, in many instances it has been determined to be inappropriate when an individual is acquitted of responsibility for the crime due to insanity. Since restitution is normally ordered as part of the penalty imposed, those who are found not guilty have generally been found not to be financially responsible as well. They may have some civil remedies available, while they're generally precluded, these victims are generally precluded from receiving restitution. They may seek recourse in the civil justice system. And Illinois has a specific civil cause of action that can be used. The compensation is a government program that also can provide payment for out-of-pocket expenses and might be used for victims of either a stranger or within a domestic violence situation. Hope had mentioned victim law. There's more information about victims' rights law can be found online at www.victimlaw.info, and we do have a special victim population for victims of individuals who are with mental illness. In order to protect the safety of victims and communities while providing treatment to those with mental illness, policymakers must devise collaborative, multidisciplinary mechanisms that will bridge the gap between the mental health and criminal justice systems. Creating a role for victims in mental health courts may be a good place to start. And although all court systems are overextended and modifications may be needed to incorporate victims' into the mental health court's context, it's helpful to keep those types of services and support that victims receive in the criminal justice system in mind. You don't have to start from scratch to make use of the existing victim services. Victim services providers can assess existing policies and practices to determine whether victim issues are adequately addressed. And they can also help integrate victim services into the context of supervision, particularly in cases where a family member has been victimized. In those cases, it may be helpful to form a collaboration with the local domestic violence shelters and coalitions. The National Center can also provide some support. The website, which is shown on the screen here, contains a lot of free information on a variety of victims' issues. Our helpline is also available for victims to call for referrals to services in their geographical location. And we send out boxes of free palm cards that contain that 800 number that can be given to victims that come in contact with the mental health courts. I think one of the most important things we can do is to continue the dialogue on these issues. We can learn a lot from each other. I now want to turn it over to Tim Murray, who will address additional information on the non-traditional operations of mental health courts, key challenges to meeting victim needs, and important reasons to do so.
Thank you, Carol. That was a comprehensive and informative presentation for all of us. I congratulate you for a job well done. And I would like to remind our listeners that Carol's last point, the one continue the dialogue, is what today's webinar is all about. I also need to thank the Office of Victims of Crime for commissioning the Justice Center's Guide to the Role of Victims in Mental Health Courts. My thanks to the Bureau of Justice Assistance for their sponsorship of work such as the work we're enjoying today, and of course to the Council for State Government's Justice Center, which has been carrying the banner that we've all been following with regard to effective treatment of those who have mental illness and are in our criminal justice systems. As Carol closed with, we're talking about a dialogue, not about answers. So the last group I have to congratulate is the 120 or so of you who have joined this webinar with us today. It's the work that you are doing that will help inform future generations in their efforts to effectively engage victims and victim interests as they attempt to deal fairly and effectively with those who come into the criminal justice system who suffer from mental illness. A lot of our effort is centered around mental health courts, and I know the array of individuals that are listening to our conversation today represent an almost equally wide array of approaches. Mental health courts take almost an indescribable variety of shapes, sizes, and approaches, but they're all bound by one common interest, and that is, again, the effective treatment of individuals who have mental illness. And they're all bound by the common essential elements shared by all, and as published by the Justice Center in their BJA publication, Improving Responses to People with Mental Illness. If you look at those core principles, at the essential elements, the very first one talks about planning and administration of mental health courts and similar efforts based upon a broad array of stakeholders. And that's what I'm going to talk to you about today more than any other issue. I think that the victims community is a stranger to many of us who are involved in the administration of criminal justice. And I also think it's fair to say that victims' topics scare many of us who are involved in the administration of criminal justice simply because of the unknown. We don't know much about the community. We don't know much about the topics. And as a result, it tends to inhibit our outreach to those groups. The third point on the mental health court is that the one thing they have in common is that they are targeting mental illness as a potential underlying cause of the criminal behavior of the arrestee. And last but most important is that these mental health court programs have developed an array of services and supervision that often reach beyond the criminal offense addressed by the court and try to reach the underlying cause, and that is the mental illness presented and the symptoms of those illnesses presented by the offender. Because mental health courts do not follow traditional case processing strategies, nor can they confine those strategies to the traditional requirements and norms associated with victim engagement. Most communities that I have seen develop their victim outreach and engagement as dictated by local and state law. Very few go beyond the strictures imposed by those laws. Yet most mental health courts are a non-traditional approach to dealing with criminal offenses and criminal offenders. As such, just as each of you have been imaginative in trying to figure out how to deal with these arrestees, how to link them with services, how to keep them behaving within the confines of therapeutic boundary, so too must you figure out how to engage and reach out to the victim's community while complying with local law. The victims of our clients' behaviors in mental health courts often reach beyond the criminal offense. There's no such thing as a victimless crime. And those of us who work with arrestees who have mental illness know that as well as anyone. Crimes that are not crimes against the person are crimes against the community. The so-called frequent flyers who come in and out of our local justice systems at enormous cost to our tax base actually make victims of our taxpayers. So we don't get a pass by saying, I only take nonviolent arrestees. We don't get a pass when we say, I only accept victimless crimes in my mental health court. Because each of our clients have victims associated with their behaviors. And often, those victims reach to caregivers and family members who coincidentally and sometimes ironically often can be our best allies in our efforts to provide effective treatment. As I said, criminal justice systems often configure their victim engagement based upon what the legislature has told them they have to do, rather than what should be done. Our local systems often have very little capacity to deal with victim issues beyond what the legislature demands of them. Mental health courts bypass traditional case process in many instances, and as a result, may unintentionally bypass the opportunity for victim engagement. Think about the mental health courts that hold cases in abeyance. They simply freeze the prosecution and the process of the case, maybe sometimes with a conditional plea entered on the record, maybe not. The client is then referred to the mental health court for treatment. Services are attached. Monitoring and supervision is provided. Nowhere has there been a trigger pulled to engage victim input or to encourage victim outreach in the models many of us follow in our efforts to have successful mental health courts. As a result, we have to develop new mechanisms to provide victims with the appropriate opportunity for input and for services, just as we developed new mechanisms to link offenders with mental illness with appropriate services and supervision, we must do the same for the victims' community. As I mentioned previously, our target populations and our offense types that we include in mental health courts do not absolve us of responsibility regarding victims. Our programs cannot diminish victims' rights just because we're trying to do the right thing with arrestees who have mental illness. I had the privilege of working last week or so with a series of 9 focus groups on an unrelated topic. And the focus groups consisted of prosecutors, defenders, pretrial programs, jailers and law enforcement, judges, county execs, probation and parole, and prison officials. In each of those groups, we included a victim advocate representative, sometime from a state or local agency or organization, most times from national organizations such as Carol's. And in each one of those separate and distinct groups, the victim's representative said the same thing, and I found it remarkable. And that is, when you talk to victims, in addition to whatever their concerns are about the individual harm that they have suffered as the result of the misbehavior of the client, the one thing they want more than anything else is the same thing that each of us want, and that is for the offender not to inflict harm on anyone else the way that they were harmed. I think if you reach out to your victim's community, undoubtedly you will hear the same message. And it's a message that each of us believe in. And as such, we will find a natural ally, not an enemy, in the victim's community to support our work. I find it ironic that we have identified offenders with mental illness as an underserved and often abused group or category in our criminal justice system, and we have gone through such spectacular distances to shorten that gap between need and service. Yet when we talk about victims, the characteristics in terms of underservice are almost identical. Just as our clients have been underserved and sometimes abused, so has the victim's community. They're not looking for a pound of flesh as much as they're looking for fairness, a chance to be heard, and the equal administration of justice, just as each of us have fought and advocated for our client base. So what can we do? Oftentimes when we talk about victims' issues, we say, hey, we can't get involved with victims because the legal system won't allow us, beyond the confines of our state victims laws, to reach out to victims in individual cases. Your behavior with regard to individual victims of individual crimes is in fact prescribed most often by your state law. The opportunity to involve victim advocates in your policy formulation, however, is only restricted by your own imagination. Bringing these individuals, their talents, their interests, and yes, their support to the table is going to be a powerful alliance that I suggest you not only need, but you should be required to have. The non-traditional approach represented by your work dealing with clients also requires a non-traditional approach in addressing victims' concerns and needs. The first and often most important step is to get this group to the table as you plan your work. They will inform your conversation, They will illuminate issues that you have never considered previously, and they will build a stronger base of support as you try and take your program forward. If your program is already underway, then now is the time to invite the victims community to your oversight group. Tell the victims community what you're doing. Tell them why. Listen to an open ear to their concerns. They may be in objection to some of your policies. Surprisingly, they may be fully supportive. Giving them the opportunity to be heard at the policy level, I think, is akin to what the state legislature has done in requiring that we afford them an effective opportunity to be heard at the individual case level. Understand the unique concerns of caregivers and family members. These individuals have lived with the ravages presented by the offender's mental illness, in some cases for decades. They're frustrated, they're worn out, and in some situations, frankly, they're scared. You are in the best position to explain to them what the program seeks to do, how it will seek to do it, and what fail-safe measures will be put in place. Service to family members, caregivers, and victims is alongside service to clients and to the community generally. Become familiar with what exists in your community and within your system. Understand when a victim presents themselves to you, how to expeditiously connect them with existing services without having to leave one bureaucracy only to wrestle with another. Become as facile in referring and connecting victims with services as you are with mentally ill clients and services. And join with victims services, join with victims groups as you advocate to fill in the gaps so that mental health can result for the entire community. Become effective collaborators. Reach out often. Reach out repeatedly. Reach out until you get successful engagement with this community. They're not used to us reaching out to them any more than we're used to having them at the table. It's time we stop referring to them as them. It's time we started referring to them as collaborators and partners. Their interests are virtually the same as ours. Thank you, and I'm going to turn it over to Hope.
Well, those were great comments, and I just want to echo two things that both of you said. First of all, that, this is very much a dialogue and an emerging issue, so we're just as interested in learning from you as I imagine you may be hearing from us. And the other key point, too, that we want to make that Carol spoke to is that there's been a tremendous body of work around victims' rights and services and supports in states. And we recognize that a lot of times mental health court team members have incredible workloads. So one of our key recommendations in our guide is really familiarizing yourself with the victims' resources you already have in your community and developing effective partnerships with district attorney and community-based victim advocates to fulfill some of the needs of crime victims in the mental health court. So with that, I'm going to provide an overview of some of the key recommendations from our guide, recognizing that, again, there's still a lot to be learned, but we heard about some innovative practices both within mental health courts and also specialty courts like drug courts that we think are really compelling examples. And all of the resources and examples that I'm going to refer to in this presentation are also available and listed in the guide that I mentioned at the outset, so you can get further information there. So just to begin, as you all know, this was a project supported by the Office for Victims of Crime. And just so you know how we kind of came up with these recommendations, we began by surveying mental health court professionals to try to learn about how a lot of folks in these settings were engaging victims. And what we found through that process was that in many cases, because in part mental health courts are such a new model, that procedures for engaging victims were ad hoc. It wasn't necessarily that team members did not want to engage victims, they just hadn't developed formalized procedures. So to get around that issue a little bit, we looked to the way that victims' rights were administered in the criminal court context and also in settings like drug courts. So this guide that we produced really analyzes two key questions. Why address the role of crime victims in mental health courts? And I think Tim just offered a number of really compelling reasons to do so. And also, after you've developed interest and you want to do this, how do you actually do it, owing to the fact, knowing that mental health courts have non-traditional operations and that victims' rights laws and constitutional amendments might not easily transfer into the mental health court setting. So speaking in particular about the right to attend, there's also often confusion because there are no hearings in mental health courts about what victims would even want to attend. There's also information sharing concerns. What if treatment or other confidential matters are discussed in the hearing? Team members may not want victims to hear that. And our recommendation here is a very simple one, and that is at the outset that mental health court team members should brainstorm about what we call court milestone events. And that may be somebody beginning a program, it may be somebody graduating from a program, but just to sort of develop a list of what those events are and then provide to victims at the outset of the process information about what those key events are, what they entail, and then perhaps leveraging a district attorney-based victim advocate, notify victims when those things happen. And in terms of confidential information being discussed during the mental health court process, in many cases, mental health court hearings are actually a matter of public record. And so what we heard in talking through this issue with folks was that in many cases it was perfectly acceptable for the victims to sit in on various events. And if confidential material was discussed, often the prosecutor and the defense attorney would approach the bench and speak privately with the judge. And we think one really interesting publication that might be useful for all of you is one from the National Gain Center, which again is listed in our guide, about dispelling myths about information sharing between mental health and criminal justice systems. Moving on to the right to be heard, and this is a significant one because often victims simply want to have their input heard by individuals who are involved in the mental health court in some way, shape, or form, and feel that as soon as someone has been accepted into a court program that for some reason their voice is no longer valued. And we recognize that a complication here is the lack of hearings and witnesses in the mental health court setting. But we still think that there are some constructive ways that victims can be heard after someone's been accepted. Our first simple one involves soliciting feedback about acceptance decisions. The Therapeutic Intervention Program in Rockford, Illinois, for example, requires written victim consent for individuals to participate in the mental health court in cases involving domestic violence. And we know that an increasing number of mental health courts across the country are taking on cases involving felony offenses and, in some cases, domestic violence offenses. Another option is to solicit victim impact statements, which may be read when it's being determined whether someone should enter the program or maybe at another point. But at the San Francisco Mental Health Court, family members are allowed to provide input, in a manner of speaking, by participating in support group sessions with participants that are hosted by a local behavioral health treatment provider. And we recognize that that very much will not work in all cases, but they found a way to make it work in particular cases, and obviously there has to be consent on both sides. Moving to the next right, the right to be informed. And this goes back to the right to attend. And again, the recommendation here is really just to identify what those milestone events are at the outset, and perhaps a court team member or a district attorney-based victim advocate can then inform victims about what all these events are and why mental health courts exist. A lot of times, an important first step is just explaining to victims why mental health courts exist and the productive things that come out of them. Another key piece of this, as Carol noted, was referrals in the community for services. And in St. Louis, the county mental health court there developed a relationship with a local victim service provider to act as a liaison to the court. And that liaison was willing to provide services to victims in the community and also direct them to other support services they might need, like compensation or how to seek out restitution and things of that nature. So again, it comes back to that point about availing yourselves of resources in your community and maybe working with local community or district attorney-based victim advocates to provide that type of key information. Another issue is this right to reasonable protection, which again we recognize is not going to be not going to be a right that necessarily is applicable to all mental health courts. But as I noted before, an increasing number of mental health courts are taking on felony cases or taking on domestic violence cases, and in those instances, it is important to take into account protection considerations. And here again may be a clear example of availing yourselves of the resources in your community. For example, in Brooklyn, the Brooklyn Mental Health Court and the Brooklyn Domestic Violence Court are both co-located in the same facility. The Domestic Violence Court has a safe waiting area for victims, and perhaps through conversations, mental health court staff members could allow victims in domestic violence cases to make use of that safe waiting area. That's just one strategy if mental health courts are co-located with other court programs. Another option, as the mental health court in Anchorage, Alaska did, they just set up a simple procedure whereby victims could listen in or participate in court proceedings by phone. It's a low-cost option, but it can be very meaningful for victims as a way to participate in the court process while feeling protected. And the last is a very tricky one that Carol spoke of as well, is the right to full and timely restitution. And this issue can become all the more complicated because often participants in mental health care and mental health courts, owing to their psychiatric disabilities, may have limited resources or inability to work. And what we recommend here is simply that the court have a liaison, at the very least, to the civil court to help prioritize financial obligations and potentially provide information to victims. And the Justice Center has released a publication called Repaying Debts. This is available on our Reentry Policy Council website at www.reentrypolicy.org. And if you go to that website, you can find this guide, which provides discussion of how state officials can help individuals meet and prioritize various financial obligations. So as Carol mentioned, there are a number of other rights discussed in our guide which are a little bit less applicable for the mental health court setting. And if you look to our guide, there's a more detailed discussion of that. So lastly, before we turn it over to a Q&A, again, I want to emphasize that dialogue is very important here. And two key questions I want to put out to all of you, and I encourage you to email me or get in touch with any of the panelists on this webinar, are to what degree are mental health courts addressing this issue currently? And have practices and programs changed since we published our guide last year? And lastly, we'd love to hear about how you all think that district attorney and community-based victim advocates can supplement services and supports to victims in mental health courts. So with that, I'm going to turn this over to a Q&A and begin with a question for victims. And that is, in some cases, I understand that mental health courts are not legally bound to uphold victim rights. What are scenarios in which mental health courts would be legally bound to uphold victim rights? Ken, did you answer that question?
I'm sorry, I didn't hear. Are you asking me?
Yes. And the question is, you mentioned in some cases that mental health courts are not legally bound to uphold victim rights. I just wondered, what are the scenarios in which mental health courts would be legally bound to uphold victim rights?
I think that category is almost endless, driven by the type of offense and offender that are included in the program and the status of prosecution associated with it. An individual who throws a rock through a glass storefront and is arrested with destruction of property may be required by the prevailing victim legislation to provide restitution. The store owner may have the legal opportunity to attend all hearings in which pivotal prosecution decisions will result. The decision to charge, the decision to divert, the decision to hold a plea in abeyance are all likely examples where the victim has not only the opportunity, but the program has the obligation to reach out and notify them of these court events, even though they're under the guise of a mental health court, which is therapeutic in its intention and in its effort.
Thank you. Carol, Are there any resources from NCVC or other organizations you're familiar with that mental health court staff members could use to better negotiate relationships with family members who are victims?
I think one of the things to start with, and I think I mentioned this, is the domestic violence field movement has made tremendous, is a very cohesive group and has made tremendous strides. And I think, just even starting with your local coalitions or if you have a state coalition, a domestic violence coalition, there's a lot of information out there. And I think talking with them and getting their input and just even learning about how they provide services and support to crime victims can be helpful.
Okay, great.
Hope, may I interject something? This is Tim again.
Sure.
I've seen mental health court programs that target probation violators, for example. Now, these are individuals who have been through traditional case process. They have been found or pled guilty. They have been sentenced to probation, and they have, on the face of it, violated probation. And the violation, by all accounts, is rooted in the presentation of mental illness, so they are then moved sideways into a mental health court. Now, that's a population that you would figure victims have nothing to do with them. There are no lawyers in the room. The case has been adjudicated. Punishment has been meted out by the court, the punishment being probation, and then any appropriate sanction as a result of the violation of probation. But it's regardless of the point in the case process that the mental health court intervenes, there is an appropriate role for victims. Whether that is a role that is case-specific, and I would guess that many of our listeners may be operating programs where case-specific outreach to victims doesn't present itself as an everyday opportunity. There is the everyday opportunity to engage victims groups and accrue their interests, concerns, and suggestions on a policy level. And so as we continue this dialogue, I want to make sure everyone has an awareness that just because you don't have the opportunity on a case-specific basis, you do have the opportunity, if not the obligation, to engage on a policy basis.
And Hope, I should also mention that mental health court staff members are welcome to call our helpline and talk with, we have victim service providers there, and they can either make referrals to specific domestic violence groups there, or they can help them talk through particular instances when they're working with family members who are victims. They have a lot of expertise, and it's what the line is there for. So that was included in the slides, and I think you're going to be posting some of that information later. But I would encourage people who are interested or have particular needs or questions, they are more than welcome to utilize that helpline.
And as I alluded during my remarks, we're working in an arena with offenders who are mentally ill with a system that has really been hurting in many regards in terms of effective engagement with this population vis-a-vis effective services and effective treatment. The same is true with the victims community. Many states still to this day really have inadequate resources invested in reaching out to the victims community. We have a wonderful opportunity as we seek to serve those with mental illness to serve our communities as a whole. And we also know that many of our clients are also often victims of crime themselves. And so we have the obligation to the overall system as well as to the community to get it right. We're trying so hard to get it right with offenders with mental illness. It isn't going to take any extra effort to get it right with victims as well.
That's a really important point. And we're nearing the 3 o'clock mark now, but I just want to get in one last question from one of our participants, and just want to indicate to everyone on the line that should you have had any outstanding questions that weren't answered, feel free to follow up with me or any of the other speakers, and we'll get back to you. But with that, just to close, one question that came in was, and I think both of you perhaps could answer this, is how do you discuss with victims advantages of possible diversion to mental health court in lieu of standard prosecution if we can't disclose the defendant's diagnosis or proposed treatment?
Let me jump in and take a quick stab at that. I think there is a conversation you can have with a victim that talks about case process. And under traditional case process, Tim, the defendant, has been accused. He's likely to be convicted or is convicted, and the sanction that we're going to suggest in court includes X amount of time in jail or X amount of supervision or whatever it may be. I can then, within those same boundaries, have a conversation that says, Tim has been identified as being eligible for this program. This program seeks the following objectives: to reduce his misbehavior by fostering a therapeutic approach that focuses on law abiding, that looks at the underlying reasons for his criminal misbehavior and a direct confrontation with those reasons using public health assets as well as traditional criminal justice supervision. In the second instance, I don't have to run the risk of betraying specific information with regard to diagnoses or specific information regarding the details of our therapeutic response, although there is also the opportunity to request and receive waivers so that information can be released on a case-by-case basis if it's appropriate. Regardless of whether or not you go down that individual path, I don't think that the ultimate goals, objectives of the overall program, the methodologies that the program uses to achieve those overall goals betrays any confidentiality. I don't think you have to go into the specifics of an individual case to explain that to a victim and have them understand not only why you're doing it, how you're doing it, and what you expect to achieve as a result.
And I agree. I think for a crime victim, just having the information of how the process works, even if it's not a specific, to help them keep their expectations realistic can go a long way. I think when victims aren't prepared in advance of what they might expect or might be the outcome in a case, that it makes it a little more difficult for them to accept what's happening.
Thank you for that, for those remarks. And with that, I'm going to turn it back to Elizabeth Meyer for some closing comments. This concludes our webinar on mental health court response to crime victims. Thank you all for your attendance and participation, and a big thank you to our presenters, Carol Doris, Tim Murray, and Hope Glassberg. A recording of this presentation, including slides and audio, will be available online by early next week on the following websites: www.consensusproject.org, www.ncdc.org, and www.pretrial.org. When you leave this event, a very brief survey on this webinar will pop up on your screen. We would very much appreciate your feedback. Thank you.